Hey you guys, welcome back to my channel. Make sure you change your chat from top chat to live chat. So we're gonna go over the Katie Joy has filed her answers to the lawsuit. Really quickly, I want to say this is not a hate stream about Katie Joy. This is not a bash Katie Joy stream. I am simply covering her lawsuit. If you are a Katie Joy follower, a Katie Joy fan, you are welcome here. I do realize there are channels that talk strictly about Katie. That is not my channel. My channel has a wide variety of content, trending news and topics, reality. It is based mainly around reality TV. But I have chosen to cover Katie in her lawsuits when my followers, would like me to. And I did ask if they would like me to keep up with this, and they said yes. So if you do not like when I cover Katie and you are a follower of mine, please feel free to sit this one out. I would beg you not to unsubscribe. Just, maybe sit the ones out where we follow the lawsuit and then, come back to the ones that you enjoy. So, you guys, this is a new sign. My friend and my subscriber, Denisa, actually got that for me, um, which was really, really, really nice of her. And I was very appreciative of her. So, as you guys know, 7M filed a lawsuit on Without a Crystal Ball, Katie. April 4th, it was filed. April 7th, they amended their complaint. August, Katie filed to have it dismissed. She filed a motion to dismiss the lawsuit. The judge ruled on that motion, denying the motion to dismiss, meaning that the lawsuit would move forward. Now, what happened next is Katie was supposed to file an answer to the lawsuit. It does not change colors. We wanted to just get one that was just it does different things and stuff. It can blink and different things, but I leave it kind of like that because if I do it to anything else, go tell your dad, babe. Go talk to your dad. If I do it with anything else, it looks like it's blinking. It looks like it's pulsating on the screen. So August, like I said, Katie filed the motion to dismiss. The judge ruled on it, saying we're not going to dismiss this. We are going to move forward with this case. Now, from my understanding, like Minnesota rule, if you file a motion to dismiss, it does like put a hold on you having to answer the lawsuit. Just in case the judge is going to dismiss it, they don't require you to, go ahead and file your answer. You are allowed, and I'm no lawyer, but I am speaking from what I've heard, like uncivil law say, or uh, what I've read online and things like that. So when you file a motion to dismiss, you don't have to file your answer in the days allotted at that moment until the judge rules whether or not he's going to dismiss your the lawsuit, right? So the judge denied that motion to dismiss, which meant from the date the judge denied it, from that date, Katie had 14 days to file her answer, which would have been September 8th, I think it was. So 14 days from the date that the judge said we're not going to dismiss this, we're going to move forward, was September 8th, I think it was. And what happened though is 7M actually gave her more time before they filed asking the judge to um, basically rule in their favor by default. So, and I was looking on Twitter and I noticed this as well. When I was looking at the documents, they had a hearing for the default judgment scheduled for 11/21, which is next month on the 21st. When I was looking on Twitter earlier, I saw where someone said, how is it that there was a hearing scheduled for a default judgment before 7M even filed the default judgment? Could it be that the court set a hearing to rule a default judgment, and that's when 7M was like, oh yeah, that's right, they haven't even answered, let's go ahead and ask the judge to do this? Not really sure, but I noticed that as well, that there was a hearing set for 11/21 before 7M filed to have it, to basically say, hey, rule in our favor. So I'm going to go over this with you guys. They filed a motion for default judgment and then they amended it. So when they filed this, asking the judge, hey, Katie's not participating in this lawsuit. Like, we need her to participate or go ahead and rule in our favor. When that happened, Katie jumped on Twitter saying, we weren't given a deadline. The judge never told us you have to, you know, file your answer by a certain date, which according to what like everyone is saying, the Minnesota rule is you have 14 days from the date the judge denies your motion to dismiss. Like, it's like automatic. It's like your lawyer should have known that. It's known by lawyers, that you have deadlines. Even if they don't say, hey, Katie, now you have a deadline, it's known you have deadlines, right? So she was saying, we didn't have a deadline. We didn't have a deadline. Now, her lawyer wrote out this letter saying, hey, we're filing our answer, and we actually thought we filed it already. Like, we had it drafted. We thought we filed it. We didn't. It was an accident, our bad, but we're filing it. And in that letter, her attorney basically said, almost threatened 7M, basically saying, you guys need to um, basically take down, you guys need to basically take down your request for default judgment because it's ridiculous. It's moot. You shouldn't have did that. If now the paperwork that we're gonna have to file, we're gonna try to ask the judge to charge you for it since we're having to do extra work. I want to read that letter really quickly. So Katie's attorney said, please find, filed, and served alongside this letter a copy of the answer that we drafted that I thought had been sent since last month. Given our typical manner of corresponding with you without delay, if you had wanted an answer and not received it, I would have thought a simple email request would be sufficient. But that's not really how attorneys go, especially if you're like suing each other. I mean, you know what I'm saying? Like, if you're in a lawsuit and you're suing someone who has been defaming you left and right, like horribly defaming you, to the point to where your income has changed drastically. You may correspond with them through emails when need be, but you're not going to go out of your way to be like, hey, so you're supposed to respond to this and I need you to respond to this. Because the thing is if you don't respond, they can ask the judge to rule in their favor by default judgment. So when they saw that you weren't responding, they're not going to ask you to. They're going to take their chances and be like, okay, let's go ahead and file this motion for default judgment. So it's crazy that, in my opinion, it's crazy that Katie's attorney would think, 7M, why didn't your attorneys just email me and remind me? It's not their job. It's not their job to remind you, Now I need to respond to the court and explain that your motion is moot and you can withdraw it. But it's not moot, it's what they're entitled to do. If you sue someone and they do not file their response, their answer by the deadline or even after the deadline, right, from what Uncivil said, saying we thought we filed a response, probably won't cut it. But it's not moot, it's well within their rights to do that. So it says, whatever the case, you now have your answer. You know my client's position on the issue, and default is not appropriate. Please advise whether we should spend our resources unnecessarily in responding to a moot motion for which there is no basis in the first place. If you choose not to withdraw your motion, I will discuss with Ms. Paulson whether she would like to seek her costs or other appropriate sanctions for misuse of resources and abuse of the litigation process. Now, every attorney that I've listened discuss this says that 7M's attorney was not abusing no process, that he was actually going with the proper process, which is what most attorneys would do. They would file this motion for default judgment. That's what they would do. I'm also seeing online, and this is just speculation, I have not seen any proof, but I am seeing online where they're claiming that Katie actually may have typed that up and that her attorney Graham, is refusing to file anything on her behalf until she pays him. I don't know. if that is in fact. I remember her on a live laughing because they hadn't filed yet and said that it would be awarded to her. I'm very curious to see what's going to happen here. Who thinks KJ wrote the letter? I mean, really, I would have a hard time thinking that any lawyer, knowing that they missed the deadline, would write something like that, and knowing that the other side was within their rights to file for that. It's really wild for me. So, what happened after that letter went out? What happened after that letter hit social media? 7M's counsel, they amended their motion for default judgment. And we're going to go over that really quickly. And this makes me think them amending it is their way of saying, we see what you said there, and we're about to basically saying it's not moot, and this is why. Okay, so they amended it. I want to make sure you guys can see it. All right, let me make me little up here and put my right smack dab in the middle of the page for now. Okay, so it says amended notice of motion and motion for default judgment. Please take notice that plaintiffs 7M Incorporated, Robert Shin, Miranda Derrick, and James Derrick plaintiffs will bring on for hearing before the Honorable Michelle Davis, Judge of District Court, its motion default judgment on 11/21/2022 at 1:30 p.m. via Zoom, meeting ID 161-260-7961 and passcode 281586. Plaintiffs will and hereby do move the court at the above stated time and place for the following for an order of default judgment pursuant to Rules 1201 and 5501 of the Minnesota Rule of Civil Procedure and other applicable law. This motion is brought pursuant. So Cate tried to say that's not Minnesota rule. It's not Minnesota rule that they can do this. So they filed again to say it is Minnesota rule. This motion is brought pursuant to the Minnesota Rule of Civil Procedure and will be based upon files, records, and proceedings herein, and the supporting memorandum and declaration submitted in accordance with the rules, together with such oral and documentary evidence as may be presented in connection with the hearing of this motion. So they, in my opinion, and from what the opinions of some people on Twitter, think that they actually amended this just to say, like, first off, this is in line. This is pursuant to Minnesota rules of civil procedure. You are allowed to do this, and when we do this, we can. It is based upon files. We have files. We have records. We have everything we need to have to prove that that she was basically in default, I guess, and they should win by default judgment. Well, I guess you could say she's in default. Like, she is in default of participating in this lawsuit. So they're saying, like, nope. Katie's over there on Twitter trying to say that it is not Minnesota rule. You don't have to file within 14 days, but they're saying, actually, we are within Minnesota rule. Let's see. Highly doubt if that was drafted by her, that would be equal defraud in the courts. She thinks liable is drafted fraud in the courts would be felony. Cate lied. That's because Cate quoted general court rules, not civil procedures. Thank you for explaining that. I gotta turn my air on. Hold on one second, guys. So there are people on Twitter that know exactly what they're talking about. Like, I swear, I think there's one person that I follow that breaks it all down really well. And I will, the name is Elle Rubin, Without a Crystal Ball Questions. And she breaks everything down, and that's what it was explained as well, is that Cate was quoting general court rules and not civil procedure rules. Not KJ being in denial. Painting my car? I am blue again today. Oh, wow. The letter was sent to 7M's lawyer, right? If so, that's not defrauding the court. Even if she wrote it, if a lawyer files it, that's legal. I did that with my... Yeah, from my understanding, you can type documents out and your attorney can file them on your behalf, and it helps cut the cost down. Where's Wooden Eagles comment? I don't know. I don't see it. But Wooden's my girl. I wouldn't. I don't. It says message retracted, but not by us. Wooden, did you delete your message, babe? I didn't even see you were here. I didn't delete it, and it's not showing that Ahmad deleted it. It just says message retracted. Oh no! Robin, I'm a retired judge. Oh, okay, gotcha. Um, doesn't posting that letter remove client attorney-client privilege? Robin, this is a question for you. Um, how's your mom? My mom, she's all right. My mom's okay. My grandpa passed away this morning, and that was not my mom's biological father. My mom's biological father passed away when my mom was 2, but this is the man that she knows as her dad. This man came into my mom's life when my mom was 5, so it's her dad. She's okay. She's okay. Denise gifted 5 LB memberships. Thank you so much, Denise. I can't wait to see who got a membership. That's always so. Oh, Lulu. Oh my goodness, thank you. All these people are people that are here normally. So I'm so glad you guys were gifted memberships. Appalachian Crochet Designs, Abby, Joanne Moore. You guys, if you are in members, go to my community post as well. Go to the community post and scroll down, and you will find a link to the Discord. We have a Discord for the members. Um, that's very sweet. Yeah, thank you so much, Denise. How do you accept it? You got it. You already accepted it. Hold on a second, you guys. Okay, guys, so we're gonna go over her answer. Now, what's crazy is she was saying yesterday, like, oh, we filed our answer, and everybody was looking for it. Everybody was looking for it. It finally did come through today. So we're gonna go over her answer, and basically her answer, she's kind of denying everything. I was muted. My son walked in, and I was talking to my son. I usually try to mute when my kids come in. Um, all right, I do apologize, guys. So let's go ahead and go over her answer. So essentially, from my take, okay, Robin, you said you were a retired judge. I am curious. Her posting that letter, does that violate attorney-client privilege? This is a letter that allegedly her attorney wrote in response to 7M filing this motion for default judgment. It's backdated. Is it backdated? It has the 5th on it. I see the 5th. Okay, let's go ahead and get into this because it's like 16 pages long. And I have a member stream tonight, and I'm supposed to take 2 of my boys to Walmart. I took one of them to Walmart last night. Well, actually, the dollar store. He is going to ask his girlfriend to homecoming, so we had to go get the stuff for that. Robin, let us pick your brain. I know that's why I'm like, I got questions, and I think you have answers. Okay, let's see. Okay, the date on this one is 10/5 at 4:21 p.m. So that was just a couple of hours ago. Criminal case law, but civil law, very safe to say. Gotcha. My kids love Walmart. They always want to go. And I'm like, my wallet does not like going to Walmart every day. You guys chill out. All right, so let's see. All right, let's keep me tiny over here. So, like I said, 10/5/21. All right. Can you guys see everything? It is their answer. It says, except as Sharon after specifically admitted defendants Cate, without a crystal ball, collectively the defendants, specifically deny each and every allegation of plaintiff 7M Films Incorporated and Robin, Shen, Miranda, and James Derrick, the plaintiff's complaint, and puts plaintiffs to their strictest proof. Defendants for their answer, an affirmative defense to plaintiff's complaints, answer as follows. So literally it says right here, it literally says, Cate and without a crystal ball specifically deny each and every allegation of plaintiff 7M, Robert, Miranda, and James complaints. And basically says, and we are asking the plaintiffs to prove everything they're stating. Which is wild. She's basically saying, we deny everything. And it's really wild because it doesn't shock me, because when she purchased my finances, literally, when she purchased my finances, people was like, why did you purchase her finances? She's like, I did not purchase her finances. And it's like, girl, you did it on your, you admitted it. You admitted it on your Instagram that you did, in fact, purchase my finances. And this, I'm not trying to go too personal with Cate, but this is something that she does. She will do something and then she will deny it. Like, I've seen it myself. So, regarding the allegations contained under parties encompassing paragraphs 1 through 6, defendants generally deny each and every allegation therein. And I think that means after to those paragraphs specifically as follows. So what I wanted to do was get the actual filing to see what she was denying, but that's going to be a lot. I couldn't pull it up, both of them up. But that would be fun. I might make a pre-recorded video, but right here it says, number 1, defendants admit paragraph 1 of plaintiff's complaint. And I think paragraph 1 is that Cate is a YouTuber. I think that's paragraph 1, that Cate Joy from Without a Crystal Ball is a YouTuber who covers blah, 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 blah. I think that's what she's admitting to. Defendants admit paragraph 2 of plaintiff's complaint and add that Shen is also a public figure. So the second one is also, Robert Shen is over management company, whatever, and he is a public figure. Defendants admit paragraph 3 of plaintiff's complaint and add that Miranda is also a public figure. Defendants admit paragraph 4 of plaintiff's complaint and add that James is also a public figure. Defendants admit paragraph 5, admit paragraph 6, admits paragraph 7, which is jurisdiction and venue. So that's obviously something to do with jurisdiction and venue, Factual background, the parties. Defendants admit paragraph 8. They admit 8 through 12, which has to do with factual background. Defendant's social media presence. Defendants are without information sufficient to admit or deny the contents of paragraph 13 of plaintiff's complaint and therefore deny the same. Defendants admit paragraph 14. So I really want to go back to see exactly what she is admitting to and what she's denying. Let me see if I can get that pulled up. That would take a long time, though. I may have to do that through a pre-recorded video. All right, deny paragraph 15 and admit they make, produce, upload videos reporting on a variety of topics with a focus of reality TV and internet celebrities. Deny paragraph 16 and puts plaintiffs to their strictest proof thereof. The thing is when they filed their complaint, and yeah, Robert Shen is not a public figure. Like, he had never even been seen publicly until like somebody that watched Cate somehow got a picture of him, sent it into Cate, for my understanding, and she put it out there. Go to owning a business and owning a management company where the people that you manage are public figures doesn't necessarily make you a public figure, in my opinion. Did she respond in the allotted time of the summons? No, she did not. So she was supposed to respond by September 8th. She did not respond by September 8th. So 7M actually filed a motion for default judgment. And they have a date set next month on the 21st for the judge to rule on that. So defendants deny paragraph 16 Put plaintiffs to their strictest proof thereof. Deny paragraph 17, asking 7M to prove it. Deny paragraph 18, asking the plaintiffs to prove it. Defendants admit that they are party to one other case currently before the court. However, the allegations of paragraph 18, and specifically any and all allegations of malicious and defamatory statements, are otherwise denied. So I think what that one is where 7M said that Cate has 2 other cases, has 2 other lawsuits where she is being sued as well. So it says defendants admit that they are party to one other case currently before the court. However, the allegations of paragraph 19, and specifically any and all allegations of malicious and defamatory statements, are otherwise denied. Maybe that's why they waited to file this. That way they could at least say, because 7M suit said that Cate has their suit and 2 others in that court being sued for defamation. That way she was like, if I can get this one with Todd settled really quickly, that'll knock one out, you know. Defendants deny paragraph 20 and put plaintiffs to their strictest proof thereof. Deny 21, asking for proof. Admit paragraph 22. Deny paragraph 23. Deny paragraph 24. Y'all, it's wild. She admits to that post regarding plaintiffs are published. However, the allegations of paragraph 25, and specifically any and all allegations of false and disparaging information, are otherwise denied. Defendants admit that the cited posts in paragraph 26 were posted. However, defendants deny any wrongdoing and specifically deny the characterization of the cited post. So that's in reference to social media disparaging the plaintiffs. Continuing disparagement. Defendants are without information sufficient to admit or deny the contents of paragraph 27 of plaintiff's complaints, therefore deny the same. Defendants deny paragraph 28 of the plaintiff's complaint and put plaintiffs to their strictest proof thereof. Deny 29, ask them to prove it. Now, count 1, defamation. Regarding the allegations contained under count 1, defamation, encompassing paragraphs 30 through 40, defendants generally deny each and every allegation therein, but I thought it was supposed to be after. So these paragraphs specifically as follows. Paragraph 30, the plaintiff's complaint does not contain any factual allegation and requires no response. To the extent that a response is required, defendants deny the same. Defendants admit paragraph 31 of plaintiff's complaint. Deny 32, put the plaintiffs to their strictest proof thereof. So them saying put plaintiffs to their strictest proof thereof is basically saying I deny that and they need to prove it. But the thing is when they laid out all these claims, when they said Cate said XYZ, it had a link right next to it to take you to where she said it. They really are talented, yeah. Hey, welcome. All right, I want to see what you said for sure. Did she respond in the allotted time? No. Based on logic, wouldn't someone who works minimum wage, pumping gas, and being a cashier be considered a public figure since they're someone you say you all out? Owning a company doesn't make you public. I have no idea who owns Kroger. Right. I mean, right. It definitely doesn't make you a public figure, in my opinion. I don't watch TikTok, so I never heard of Miranda, Derek, or any of these parties. I had never heard of them either. I mean, they were getting kind of popular, but Robert Shin was not. Deny paragraphs 33, asking them to prove it. Deny paragraph 34, asking them to prove it. Deny paragraph 35, 36, 37, 38, 39, and 40, asking them to prove it. Defamation per se. Regarding the allegations contained under count 2, defamation per se, encompassing paragraphs 41 through 52, defendants generally deny each and every allegation. So paragraph 41 of plaintiff's complaint does not contain any factual allegations and require no response. To the extent that a response is required, defendants deny the same. All right, so let's see. Paragraph 42 to 48, Cate is denying and asking that 7M prove it. Defendants are without sufficient knowledge or information to form a belief as to the truth of all of the allegations in paragraph 49 of plaintiff's complaint and therefore deny the same and put plaintiffs to their strictest proof thereof. Defendants specifically not deny that any statements were false. Defendants are without sufficient knowledge or information to form a belief as to the truth of all the allegations of paragraph 50 of plaintiff's complaint, and therefore deny the same and put plaintiffs to their strictest proof thereof. Defendants specifically deny the statements were false. So 51 is the same. They deny sufficient knowledge or information to form a belief as the truth. They deny the same, put plaintiffs to their strictest proof thereof. Defendants specifically deny that the statements were false. That's for 52 as well. Torturous interference of contract, which they literally can prove this. Like, I remember what these were, the torturous interference of contract. I remember what they are, and they have proof. Her lawyer would have insurance, and he would know if she has the money to sue him. Plus, suing your lawyer is bad form when you're always in need of a lawyer. Yep, exactly. So, regarding the allegations contained under count 3, torturous interference of contract, encompassing paragraphs 53 through 62, defendants generally deny each and every allegation therein. I don't know how she could deny it, like, really. 53. Complaint does not contain any factual allegation and requires no response. To the extent that a response is required, defendant denies the same. Deny paragraph 54, deny 55, deny 56, deny 57, asking 7M to prove it. For 58, defendants are without sufficient knowledge or information to form a belief as to the truth of all of the allegations of paragraph 58 of plaintiff's complaint, and therefore deny the same and put plaintiff to their strictest proof thereof. That's the same for 59, 60. Or for 60, it just denies it. Denies 61. 62, defendants are without sufficient knowledge or information to form a belief as to the My thing is, okay, here in all these where it says defendants are without sufficient knowledge or information to form a belief as to the truth of all the allegations of paragraph 62. Well, paragraph 62 is obviously where she says something defamatory about 7M. But now she's saying, well, I really don't have enough information or knowledge to know if that is true or not. I think that's what she's saying. Like, what I said there, like, I really don't know for sure if it is true. But I'm denying that I said it. I mean, I think commercial defamation. Regarding the allegations contained under count 4, commercial defamation encompassing paragraph 63 through 74, defendants generally deny each and every allegation therein. Paragraph 63 of plaintiff's complaint does not contain any factual allegations. It requires no response. To the extent that a response is required, defendants deny the same. Deny paragraph 64. Deny paragraph 65. 66. Not enough knowledge or information. If there has to be an answer, then she denies it. Denies paragraph 67. Denies paragraph 68. Admits paragraph 69. It says, defendant admits paragraph 69 of plaintiff's complaint to the extent that certain statements have been posted to defendant's social media pages. Defendants specifically deny all the other allegations in paragraph 69 of defendant's complaint and put plaintiffs to their strictest proof thereof. Defendants deny paragraph 70, deny 71, 72, not enough information, but not enough information to form a belief, but still going to deny it. 73, same, not enough information, but if they have to get an answer, deny it. Same with 74. All right, count 5. Intentional infliction of emotional distress. So, encompassing paragraphs 75 through 83, defendants generally deny each and every allegation. 63. Complaint does not contain any factual allegation and requires no response. If it does, I deny it. Deny paragraph 76. 77, defendants are without sufficient knowledge or information to form a belief of the truth of the allegation in paragraph 77 of plaintiff's complaint and therefore deny the same and put plaintiffs to their strictest proof thereof. Same with 78. Deny 79. Admits to paragraph 80. Says the statements have been posted to the defendant's social media pages. Defendants specifically deny all the other allegations of paragraph 80. And they need 7M to prove it. Admits to 81. Says the statements were posted to the defendant's social media pages. Defendants specifically deny all the other allegations in paragraph 81. Deny 82. 83. Defendants are without sufficient knowledge or information to form a belief. Negligence per se. So this is through paragraphs 84 through 90. 84 does not contain enough information, but I'm going to deny it. Deny 85. Deny 86. Deny 87. 88 without sufficient knowledge or information, but if I'm going to have to give you an answer, I'm going to deny it. Same with 89. Same with 90. Deceptive trade practices, which is paragraphs 91 through 95. 91 doesn't have any factual allegation, requires no response, but if it requires a response, I'm going to deny. Defendant admits to paragraph 92 to the extent that certain statements have been posted to defendant's social media page. Defendant specifically deny any and all wrongdoing. Deny paragraph 93. Deny paragraph 94. 95. Gonna deny if she has to. But obviously not enough information. Let's see. Is this count 8? Did we go from, wait. Oh yeah, okay. Which is intentional interference with prospective advantage. So paragraphs 96 through 102. Where I think this is where they're talking about job opportunities, how she interfered with that. Give me just a second, you guys. Sean brought me dinner a while ago because I'm kind of working late tonight. Y'all, if I was getting caught up in stuff like this, Sean would be like, no more. Sean would be like, no more. So I think when you sue someone and you claim they defamed you, I think you have to prove that they did, right? Isn't that how it works? You have to prove that they did in fact defame you, but they have the proof. Y'all don't want to hear my husband talk about this, which he probably don't want to take. He cannot stand like really listening about anything Katie Joy anymore. But he would be like, "Oh my God, are you serious?" Paragraph 96, not enough factual information to require a response, but if it is required, I'm going to deny. Same with 97, deny paragraph 98, deny paragraph 99, deny paragraph 100. 101, not enough information, but if I have to give you an answer, I'm going to deny. Same with 102. Injunctive relief, which is in regards to paragraphs 103 to 108. She denies each and every allegation. Paragraph 103, not enough information to extend to require a response, but if a response is required, I'm going to deny it. Deny paragraph 104, deny paragraph 105, deny paragraph 106, 107, 108. Plaintiff's jury demand does not contain factual allegations and therefore no answer is required. To the extent that an answer is required, defendants deny the same, which is to a jury demand. Request for relief. Plaintiff's request for relief does not contain factual allegations and therefore no answer is required to the extent that the answer is required. Defendants deny the same. Affirmative defense. Plaintiff's complaint fails to state claim upon which relief can be granted. I think they stated a claim. Everyone that I have watched has said this is a really good case. That 7M has a really good case. Each of plaintiff's 9 counts, as pled in paragraph 30 through 108 of plaintiff's complaint, state claims solely against defendant Catherine Mckee Paulson. Plaintiff's claims in paragraphs 30 through 108 a plaintiff's complaint do not state a cause of action against Without a Crystal Ball LLC, and Without a Crystal Ball should be dismissed as a party. What? You are Without a Crystal Ball. Like, you did it on... Okay, you are the person, Katie Joy. Your company that you work through is Without a Crystal Ball. So you made these claims under your Without a Crystal Ball channel and through your Without a Crystal Ball Twitter and Instagram. So they should definitely should not be dismissed. That's wild. Defendants hereby incorporates, as it fully sets forth herein, all of the affirmative defenses in Minnesota Rule Civil Procedure 8.03. Defendant statements are true and therefore not defamatory. Defendant statements are true and therefore not defamatory. Alternatively, defendant statements are statements of opinions and therefore not defamatory. No. Katie has stated straight up that these things were like true. It was a lot of things were not stated as an opinion. Defendants reserve the right to assert such additional affirmative defense as may be appropriate and as learned through the course of discovery and up through the conclusion of the trial in this matter. Okay, so no, she's never showed any proof to anything she's ever said about 7M that I'm aware of. Also, so then she was like, we're not the one that missed the deadline. 7M missed the deadline. So she was wanting, the thing is, she filed a motion to dismiss, right? Right. Accusing someone of trafficking isn't an option. It isn't an opinion. And what they're basically asking is if the judge rules on a default judgment, that's what they want, is $1 million. Like, hey, $1 million, rule on this default judgment, it'll be done, $1 million. But if they go further with this, they may ask for more. Right, contact these 7M sponsors and people they have contracts with, and telling them this is what they do. Do you want to be linked to someone that does XYZ? And them saying, oh, no, never mind, we sure don't. That's not an opinion. You did not state those things as an opinion when you reached out to the companies that they were working with. But I was reading something. Let me see if I took screenshots of it. Because I thought, oh, wow, that's very true. So basically, she was wanting them to respond. Okay, 7M filed a lawsuit. Instead of KJ and her team filing an answer to the lawsuit, they filed a motion to dismiss. The motion to dismiss was denied. KJ still has not filed an answer, which she has now. But it is 7M's fault for not providing discovery on a lawsuit that KJ hasn't answered. So that's what KJ is saying. KJ's like, they missed the deadline. They missed the deadline. So you wanted them to file on something that you ain't even filed an answer to? You know what I'm saying? Somebody said that is a perfect synopsis of events. It most certainly laughable at this point. Even those with no legal background understand that's not how it works. And KJ is over there huffing and puffing, stomping her feet because she thought, let me go back to that. Because she thought people were going to believe her. So basically, how much sense does this make? Because Katie's over there yelling, they missed the deadline, not us, not us. So 7M files a lawsuit. Instead of Katie and her team filing an answer to the lawsuit, they file a motion to dismiss. That motion to dismiss was denied. KJ just now filed her answer, which was due almost a month ago. But it's 7M's fault for not providing discovery on a lawsuit that Katie didn't answer at the deadline, and she even filed a motion to dismiss. So it's really wild that she would be after them to not miss deadlines when she's over here missing deadlines. You know what I'm saying? The waterboarding accusation was absolutely mind-blowing because if someone was waterboarded, it would have been a criminal case long before KJ could have reported on it. Exactly. She has to answer. Yeah. Oh, this KJ is having a downfall. I think Todd should be held accountable for both actions. Todd wants to do. They need to say goodbye to the house. Yeah, I mean. And does 7M have to provide discovery, or is that Katie? I think both sides may I don't know. That's a question maybe for Robin, because I'm really not sure who provides discovery. But you get like discovery. Everything goes in an order, from my understanding, right? The Twitter account, it always has a lot of um breaks it down really well. All right. It's L. Rubin without a crystal ball questions. Um, all right, we're gonna read some of the chat, but let me see because I do want to go back because it was kind of wild to see that she just denied everything. I mean, everything. And it's like they have proof of it. So I'm definitely going to be on that Zoom call, that hearing on the 21st. Bet your sweet honey I am. All right, let's see. Amended summons and complaint. Let's do that. Go over a few of the things. I have a live for the members scheduled at 8. Um, and I got to take Eli to Walmart. All right, let's see. All right, so one, she admits. One is 7M is a California corporation organized and operating pursuant to and in accordance with the laws of the state of California. She admits to that one. Two, she admits to, which is Robert Shin is an individual resident of the state of California. She admits that Robert Shin is a resident of the state of California, but then says, and to add to, he is also a public figure, which I don't think that he is. Three, she admits to three that Miranda is an individual of the state of California, also adds that she's a public figure, which Miranda, you could say that she is. James, she admits that James is an individual of the resident of and a resident, an individual resident of the state of California, and as he's a public figure. Four, she admits. Five? Let's see, five. She admits to 5, 6, 7, 8, 9, 10, 11, 12. So she admits to 5, 6, 7. Okay. She admits that she is a resident of Wright County, Minnesota. She admits that Without a Crystal Ball is a Minnesota limited liability company organized and operating in accordance to the state laws of Minnesota, with whatever address. She admits the jurisdiction, which is the court has personal jurisdiction over all defendants. She admits to, down to 12, okay. She admits that 7M is a talent management company located in the state of California. She admits that Robert Shin is the CEO and sole owner. She admits that Miranda and James are clients of 7M. She admits that upon information to believe Katie Joy is an internet personality and the owner of Without a Crystal Ball. She admits that Katie Joy, through Without a Crystal Ball, monetizes her social media presence on YouTube, Twitter, Instagram, TikTok, and Facebook. For 13, she says there's not enough information to. For 13, she says there's not enough information to prove this. But if you do require an answer, I'm going to deny this one. And this was interesting because 13 is defendant Katie Joy runs and uses various social media usernames on various platforms, including but not limited to. So she don't want to answer this one. She says it's not enough information to prove this, so I'm going to deny it. Without a Crystal Ball, Instagram. Cults Yuck, Instagram. Exposing 7M, Instagram. Without a Crystal Ball YouTube, Without a Crystal Ball Facebook, Without a Crystal Ball official Twitter, Katie Joy Without a Crystal Ball Twitter, Without a Crystal Ball TikTok. So some of those she's denying. She's saying, well, there's not enough information here to say that this is true, so I'm just going to deny it. 14, she admits that Katie holds herself out as an internet blogger. 15, she denies. 15 through 18. So Katie Joy, 15 through 18. So 15 is defendant Katie Joy makes, produces, and uploads drama and or T videos and internet postings on various social media accounts. She denies that one. Defendant Katie Joy intentionally publishes false and defamatory material to denigrate others through sensationalism and fabrication of perceived drama for the sole purpose of enticing followers and viewers to help defendants monetize their various social media accounts. So she denies that one. She denies that she engages in internet trolling under her own name and various pseudonyms for the purpose of harassment and causing others grief, emotional distress, financial ruin. She denies that. She denies that she has a history of intentionally, maliciously, and recklessly publishing false and or misleading information about various people and entities, including the plaintiffs. So she denies these. She admits to 19. Currently has at least 2 other lawsuits in this court for her malicious and defamatory statements. That's actually the one that she admits to, but then says it's not 2 anymore. It's just 1. Number 20. She denies 20 and 21. 20 is she holds herself out as a established YouTube personality and self-proclaimed internet troll with a professed obsession with 7M. Denies. She denies that she has openly stated that she will not stop going after plaintiffs until nobody works for them. I've seen her say that. So 22, she admits. 22 is that Katie Joy has hundreds of thousands of followers on various platforms. 23, she denies. 23 is Katie Joy is determined to continue exposing plaintiffs, their associates, and any business who contracts with them until they are ruined. She denies 24, which is defendant Katie Joy has been sharing private and confidential information about the plaintiffs and their associates to social media pages with the intent of causing harm. She's did all this. It's crazy that she denies these things that, like, she's on film admitting to. You know what I'm saying? How is she gonna? I don't know how you deny these things. 25, she admits one part of it but denies the other. Defendant Katie Joy and proper posts have been published to and are accessible to the general public. She admits that, but she denies that her posts contain false and disparaging information about the plaintiffs. 26, admit but no wrongdoing. So at 26, she admits this one but states that there was no wrongdoing in this. 26 is defendant Katie Joy has made the following social media posts, which include false statements of facts, malicious and misleading statements, defamatory statements about plaintiffs and their associates, and calls for her followers to stop doing business with the plaintiffs. So she says, yeah, I made these posts, and I encouraged them to stop doing business with the plaintiffs, but I don't see anything wrong with that. Where'd you say 27? Okay. 27. Doesn't admit or deny. On March 10th, the plaintiff sent a cease and desist letter to defendants instructing her to discontinue any and all claims about 7M, Robert, Miranda, and James, and any client stands associated, and asked her to remove all postings she had already made. So she doesn't admit or deny that one. She denies 28. Defendant did not respond to the cease and desist letter and continued posting false allegations about plaintiffs and their various clients and associates daily, if not hourly. Plaintiffs reserve the right to amend these pleadings to include any and all posts made after the last of the listed posts to incorporate them herein. She denies 29. As a direct result of the defendant's false and defamatory statements, plaintiff's reputation and standing in the community has been irreparably harmed. Denies that. 30 through 40 denies. 30 is plaintiffs restate and incorporate by reference all paragraphs previously set forth. Katie Joy's communication on all the posts outlined in the chart in this complaint, the false statements, in addition to other statements on various platforms to hundreds of thousands of people through her various social media platforms. The false statements are categorically false. Katie Joy knew the statements were false when she made them, or at least acted with reckless disregard. She's denying that. Katie Joy was informed of the falsity of the statements after they were posted. She denies that. She denies that she made false statements with malice. She denies that she made false statements to further her own financial interest. She monetized the web traffic from these sensational and false claims. The false statements have caused and continue to cause a plaintiff significant reputational harm, mental distress, humiliation, hatred, and contempt and embarrassment. She denies that. Where do we get to? Admit. To 40, she denies. As a direct and proximate result of the conduct of defendants' false statements, plaintiffs have been shunned, avoided, and injured in their occupation or business. She denies. By refusing to take down the defamatory post and continue to create new content with the additional defamatory statements on multiple platforms, Katie Joy continues to make false, misleading, and defamatory statements. She denies. As a direct and proximate result of the defendant's false and defamatory statements, plaintiffs have suffered damages in the amount to be proven at trial, but reasonably exceed $1 million. She denies. 41 through 52, she denies. Plaintiffs restate and incorporate by reference all paragraphs previously set forth. Katie Joy communicated the false statements to hundreds of thousands of people through her various social media platforms. Katie Joy contacted individuals and organizations directly to disparage the plaintiffs. I can't believe she's denying that. Like, she's denying contacting individuals and organizations directly to disparage the plaintiffs. All of the false statements made by Katie Joy, as outlined in Section C of the factual background of this complaint, are categorically false. Katie Joy knew the false statements were false when she made them, or at the very least, acted with reckless disregard. She's denying that. Katie Joy was informed of the falsity of the statements after they were posted. She denies. Katie Joy made the false statements with actual malice. She denies. Katie Joy made the false statements to further her own financial gain. She denies. The false statements accused plaintiffs of committing crimes of moral turpitude. These allegations have harmed plaintiffs in their trade and in their personal lives. She denies. The false statements have caused and continue to cause plaintiffs significant reputational harm, mental distress, humiliation, hatred, contempt, and embarrassment. She denies. As the direct and proximate result, they've been shown, avoided, and injured in their occupation and business. She denies. As a direct result, they are believe they have suffered damages to be proven at court, but reasonably believed to exceed $1 million. She denies. So I have all those written down. So those are the ones. I mean, we still have 50 more to go, but those are the ones that I actually got to write down before we went live. She basically denies things that can absolutely be proven. It's really wild. It's really, really wild. The proof is there. I think KJ and Todd are going broke, and I have feelings soon she will be. Well, the thing is, it's she is still making money every month. Like last month, she made about $30K. Hopefully, she'll pay her lawyers. I mean. But you're not going to be able to keep up. She's not going to be able to keep up, though, if, she continues getting sued. No doubt, she settled with Todd. And some people say it was a win. Some people say it was a loss. I say it was a win for both of them and a loss for both of them. Can they ask for character witnesses? I don't think so. I'm really not sure, but I don't know. I don't know if you can ask for character witnesses in a defamation trial. Negative testimony against you by a family member or other witness in a child custody or divorce hearing usually doesn't give you cause of action for a defamation lawsuit. That's not what I was asking. Did she say being sued is a badge of honor? She did say that. Yes. Yeah, she's denied things I've seen her do. It's really wild. And my thing is like, if I was a judge and I am, over a defamation lawsuit and they say, this is what this person said. And the person says, I didn't say none of that. And then they start showing the proof. Like, well, here's the proof where she did say this. Here's the proof where she did say this. Here's the proof where she just, at one point I would say, that's enough. I've seen enough. It's clear she's a liar. I've seen proof that she has said things that she's sitting there in front of my face in my courtroom denying. So at this point, you lose because you're a liar. And have a rule in their favor. I mean, my goodness. You know what I'm saying? Hey, babe. I was hoping you brought me a root beer. You okay, babe? Can they play her videos in this case like they did in Amber Heard and Johnny Depp? If I was KJ, I begged 7M to sue. Has KJ deleted anything yet? I think she has. They're listed in the claim and actually in court. Hey, Amanda. I mean, I'm not saying to do this type of work, especially with a channel her size, is it possible that you could get sued by someone who's ticked off at you? Absolutely. But, I don't know. But, to be sued as many times as she is, thank you, babe. To be sued as many times as she is, that's not a badge of honor. Like, you could say, like, one time, okay. Like, Cheyenne, Floyd, and Zach, apparently they were saying they were going to sue me, It would be really wild for them to file a lawsuit against me. I don't think it would go anywhere. But to be sued as many times as she has, it's because she covers things, stating them as facts, and she does it in such a negative, nasty way. If she doesn't like someone, she does whatever she can to convince the public that they're terrible people. Absolutely, all apologies. Absolutely. She must be losing more money in costs and lawyer fees than she's making. Yeah. Is she going with the defense that unless they're within the room with her, they are unable to prove it? I don't know. It's really wild. But Rakita Law got kicked off his platform. What? Really? I don't know Rakita Law that well. But how? It takes a lot to get kicked off YouTube. I mean, it takes a lot. This is really wild too. I don't know. They're going to, even if she deletes, the internet is forever and everything she still said in the platform servers and can be requested. Everything has been clipped as well. Well, that's the thing is, before someone sues you, they're going to get the evidence first. They're not going to sue you and then try to get it. You bet your sweet tushy that before they even send you the cease and desist, they're like, record, download. They're getting that evidence. Because most of the time that is what happens. You send a cease and desist and they're like, oh, delete. You know what I'm saying? So they have the evidence before it's even, anybody even knows that they're about to sue. Tega's going hard. He's suing because of CBS is being called. Yeah, I saw that. Has she ever been before a jury or just settled? She's always settled. It's either been dismissed due to jurisdiction or settled. what's so crazy is everybody's like, oh, she settled with Tati. She settled with Tati before Tati even sued her again. Sorry if this has been asked. It hasn't, but this is a really good question. If she wants, without a crystal ball, LLC, her company, to not be a part of the suit, then if she has business insurance, would that mean that the insurance would not pay for her personally? Well, I would imagine, because the LLC is what holds the insurance, I think, right? So I would think that they would not pay for it if it's just her being sued. But they are within their rights to sue her as her LLC because the platforms that she has, um, attacked them or lied on them, disparaged them over, was through her Without a Crystal Ball accounts. It wasn't on her Katie Joy YouTube channel. It wasn't on her Katie Joy Instagram. It was on her Without a Crystal Ball. Don't forget, yeah, Jilly Juice sued her, but that was jurisdiction. Now the thing is with Tati sued her, and it was dismissed over jurisdiction. It was dismissed jurisdiction. The thing is they flew to Minnesota, and they were about to file in the correct jurisdiction, and they met with Katie's attorneys and was like, "Hey, listen, we're about to file in your jurisdiction." And Katie said, "Whoa, whoa, 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 whoa. In my opinion, this is what I imagine happened." She said, "Whoa, whoa, whoa, whoa. No need to file. What do you want? What do you want? Say you don't file. I don't want you to file." Because if Tati would have sued her in the correct jurisdiction, which is what was about to happen, I think Tati would have won, in my opinion. Yes, Jilly Juice. So Jillian Epperly is a woman that formed this drink, and she thought that her drink could cure everything: cancer, AIDS, syphilis, herpes. If you cut your arm off, you could drink this drink for months and your arm would grow back. I mean, she was a real, you know, character, so to say. I mean, she was featured on Dr. Phil. Katie obviously took like a liking to her, but not so much. Like, obviously, Katie started covering her, saying that it was crazy and that she was out of her mind and blah, 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 blah. But there was this guy who was terminally ill. He was sent home from the hospital on hospice, wasn't supposed to make it. And he started drinking the juice because, rumors were this juice could cure you. So he started drinking the juice. He ended up passing away. Well, Katie made claims that the juice killed the man. But from my understanding, the man was literally sent home from the hospital on hospice, not expected to make it. The whole reason he drank the juice is because he was out of options and he was about to die. So when he died, Katie said the juice killed the man. And Katie started writing on patios about it and talking about it on the non sequitur channel. So Jillian Epperly filed a lawsuit, but it was dismissed due to jurisdiction. Yes, settling does not necessarily mean you get money. It doesn't. Bankruptcy won't cover anything owed from the court proceedings, court fines, and also I heard if they proved that it was that she defamed them like maliciously, if it comes out that she knowingly lied, then I heard they don't cover defamation if you lose because it's proven that you did something on purpose. I don't think KJ got any money in the settlements both. And the thing is, if anybody was going to get money, in my opinion, the person that I would think would get the money would be Tati or Todd. Like, they were the ones suing her. So usually the person suing someone, if they settle, they're the ones getting some money, not the person being sued. You know what I'm saying? Like, when I sued the police department, it wouldn't make much sense for me to sue them for what they did wrong to me, and they win money. It would have been, if anybody was going to be awarded any money, it would have been Todd, it would have been Tati. But basically, from my understanding, what their settlement was is that for Tati, Katie was not allowed to talk about her in a negative way at all anymore, and that Katie had to put out this statement saying that the things that she said was incorrect information given to her by a disgruntled business partner, and she threw the business partner under the bus and told Tati, he is who I got my information from. So all the lies that I put out about you guys, I didn't know they were lies. He told me. I thought they were true. And Katie ran with the same story that she ran with concerning Steve and Kail. I was manipulated. I was manipulated into believing all these things, and I repeated them because I actually thought they were true. Um, yeah, I didn't think so. Um, yeah, the Jillian Epperly Jilly Juice, I think, is over on YouTube on Dr. Phil. Yeah, KJ gave up her sources. And my thing is like somebody that is, you claim to be a journalist, but you throw your sources under the bus like super quickly. Good night, good night, good night. Let's see, what else was it? Todd, I think their agreement was she not talk about him anymore. Um, I think Kyle's like on the run. I don't know that for sure, but I know he had warrants or something because he didn't show up in court. I mean, there was he filed documents that were fake, from my understanding. It was a whole big old thing. If there was a YouTube Big Brother, would you go in? L? Sorry, off topic, but I got a few I'd be fascinated with. If there was a YouTube Big Brother, I don't know much about Big Brother. Don't they all go into a house and stay together and like compete in games and stuff? It depends on how long it would be because like I have kids. If my kids were older, yeah, but not the age they are now because my kids are not used to mommy being gone. Like, I mean, they come out here all throughout the day if I don't go in there as much. Didn't that happen to Lindsay Chrisley? Um, I'm not sure because I forgot what we were talking about. KJ probably will be uninsurable after she gets non-renewed from her current insurance. No underwriter in the world would risk having her insured. That's what I've heard as well. Um, I agree, Robin. This one you just read at 7M says she had two other outstanding lawsuits. But KJ said now there's only one. So which other one? So I think they were counting Steve McRae and maybe Todd. I'm not sure. But Steve is definitely off the record, I would imagine, because he didn't actually serve her in time. Now the Todd Chrisley one, they just settled. She was already talking about Tati before Tati's business partner got a hold of her. She sure was. She got her first like 2 cease and desist, or 3, I think, before Tati's business partner even contacted her. Oh my goodness, that would be wild. Wait, would you go if you knew KJ would be on? Yep, I would go. Yeah, sure would. It would be fun. How many people is she gonna pick on? I mean, until she learns her lesson, I guess. But I do have a member stream in like 15 minutes, you guys. So I'm gonna go ahead and close this one out. And my son's like, Mom, when are you taking him to Walmart? She talked about the Swansons too. Yeah. Let me tell Eli. Oh no. No. Y'all, Sean. Dang it. Um, I pay to watch it. It will be interesting. I would love to meet Todd. KJ has flown under the radar and gotten off small flaws. This time I think and hope she's banned. I'm sick of it. Yeah. Why did he get banned? I'm super confused on that. I mean, I don't know much about him, but he can't be like Katie. Isn't he the one that's got like long gray hair. Completely removed it for a third strike. This is unacceptable. Do better with silencing legal community on major. Looks like he got 3 strikes. Wow. That's terrible. It's terrible. Now that Derek Dillard is a case, I can see him building a case. He defends his family hard. The thing is Derek Dillard actually communicates with Cate, and I know that to be true. It's wild that he would do that, especially considering that Cate, like 2 years ago was like, I hate Jill because she's married to Derek, and Derek is just, ugh. Once about, I don't know, he actually did start reaching out to Cate, and he was sent the clip of Cate saying, I hate Jill. He was. And he basically was like, well, they benefit each other to talk to each other, essentially. Allegedly, what I heard. I don't know why he would, because she literally talks so bad about his family. If you notice now, though, she does not talk bad about Jill or Derek. She talks really good about Jill or Derek. But before, she said terrible things about them. But yeah, so I'm like, you could contact any other YouTuber. He could contact me. I've never said anything bad about him. I've never said how much I hate him or his wife. I actually like them. But, whatever. People usually learn their lesson. Because Cate is really bad about outing her sources. That's one thing. I might out somebody else's sources, but I ain't outing mine. And I'll just say allegedly. Like, I think they talked to her. That's what I heard. She called him things I would not call my worst enemy. Yeah, once I get my head around that, because the girls actually the police former flake in their record, I'd be very cautious if I was Derek. Yeah, he's been informed. But I'm gonna go ahead, and that is terrible when your channel gets shut down for mass flagging. That is horrible. I think this is a loss situation for KJ. If the judge accepts, she loses, and she accepts, go to the next step, she eventually loses. Here's the thing. Cate considers the Tati Westbrook a win. Obviously, the Jilly Juice a win. She considers the Todd Chrisley a win. And in my opinion, I think it's a win and a loss for both of them. So it's a win for Cate because it stops right there. She don't have to continue the fight. So it saves her money in the long run with the lawsuit if it would have continued. It's a loss because she's not going to be able to cover him anymore. So if he gets a new trial, when they get sentenced, she cannot cover his sentencing. She cannot cover if he gets a new trial, that at all, and that was a moneymaker for her. So it's a win and a loss for her, and it's a win and it's a loss for him. It's a win because it saves him money. He don't have to move forward. And because he has all these other situations going on right now, he's paying for this lawsuit that he's, being convicted of, or it's not even a lawsuit, the charges. He's fighting these charges with the IRS, which is costing him a lot of money. And then he's being sued by an IRS investigator. So he's already having to put out a lot of money for legal fees and lawyers and things such as that. So it's a win for him because this is one less suit he's got to worry about. It's a loss for him because I know he wanted to put Cate in her place. Like, I know he wanted to put Cate in her place. I know he wanted to be the one to end Cate's YouTube career. And he's not going to be able to do that. So it's a win for both of them, and it's a loss for both of them. It'll be the fact that KJ wants her LLC removed from the complaint shows she is worried about her YouTube. Is that what it is? Is that what it... That would make sense, I guess. In my opinion, better to breed positivity than negativity, especially when you have a child, children, no unnecessary legal problem. Exactly. Thank you guys so much for hanging out with me tonight. I wanted to go over the answers. Like I said, I've asked, my followers, like, hey, do you guys want me to go over this? Everyone says yes, which is why, I do decide to do it, because I know some people don't like for me to go over KJ stuff. But I do want to do what the majority asked me to do. Anybody that's not into it, I would appreciate it if you don't unfollow me. Just sit the ones out that you are not interested in listening to, you know. But everybody else, leave me your thoughts in the comment section below. What way do you think this is going to go? Katie has 11/21. The 21st, there will be a hearing where the judge will rule on whether or not he's going to grant this default judgment. I'm going to be there. I will be there, or I will be square. One or the other, and I don't want to be square, whatever that means. So I'm going to be there, and as soon as we get word, I'll hop on a live stream. That is my hubby's birthday, so I will have to, hang out with him that day as well. I'll try to research Minnesota civil law tomorrow. That sounds so good. Email me as well, because I would love to ask you some questions. I have a member stream in 7 minutes. So, well, she says that Tide defamed her, that Tide lied on her on his podcast. So she's suing for defamation. I'm going to post the link to the member stream again on the community tab. So if you are a member, Minnesota has an against cyberbullying and cyber harassment, cyber stalking laws. CKJ is doing that. Yes. Thank you, Robin. So you guys go to my community tab in about 3 minutes. I'm actually going to have it up, and you can find it. Patreon, if you're a Patreon member, it'll be over there, and we'll be live in 6 minutes to read more of Jeanette McCurdy's book. It's a really good book. I'm Glad My Mom Died is the title of it. So very interesting, and it's about to get really wild. So I will see you guys in just a little bit. Leave me your thoughts in the comment section below. Make sure you give this video a huge thumbs up, and I will see you guys in the next one. Members, I'll see you guys in a few minutes. Bye, everyone.